And if I can get this thing off me and on to Bob, I will now turn you over to Bob Donaldson.
The dinner. Let me start by stating the obvious. I suspect that no area of law is more gray than foreign investment. However, that notwithstanding, you'll be amazed to learn how fear controls the many ways in which foreigners affect our personal lives. The Cabinet has become a surrogate mother to Canadians, but her primary concerns may appear to be a little bit unusual. Like any good mother, the Cabinet is concerned about what Canadians eat. You may think that any mother would want her children to eat fish, but the Cabinet thinks that the type of fish is crucial. In 3 separate decisions, the Cabinet decided that foreigners could not establish a business in BC to be engaged primarily in the production of herring roe and to purchase, process, and sell fish in Halifax. The Cabinet, however, did conclude that Canadians should eat tuna, even tuna caught in foreign waters, and accordingly permitted a foreign corporation to acquire a major tuna manufacturing facility in New Brunswick. Man does not live on tuna alone, however, and the Cabinet knows this. On December 10th, 1981, it permitted a foreign corporation to buy a business engaged in the breeding of turkeys. But within the last 3 months, however, it refused permission to a non-eligible person to establish a pizza shop in Maple, Ontario. It did, however, permit a foreigner to establish a delicatessen, but not to think that the Cabinet is all meat and potatoes. Within the last 3 months, it approved a foreigner's business to import and export gourmet products. One would have thought that any good mother would prevent her children from drinking too much. But again, the Cabinet is not concerned if her children get inebriated, but what they drink to accomplish that end. Fine foreign beers are apparently okay. Although the Canadian standard of beer is high, it does not appear that the wines are going to get any better. On April 24th, 1981, the Cabinet prohibited Gilbey's from buying Barnes Wines, a producer and distributor of Niagara grapes. Although we can drink beer with our delicatessen meats, the Cabinet was concerned that Canadians would have something to drink with the newly available gourmet products. Accordingly, on March 30th, 1981, it permitted a business to blend and market pre-mixed cocktails, but no liqueurs. And perhaps to wash down the tuna and turkey, the Cabinet allowed a foreigner to establish a business to import and market a herbal water alcoholic drink in Toronto to help digestion. But there will be no drinking from glasses. The Cabinet recently approved a new business to permit foreign corporations to manufacture continuous plastic drinking straws. The Cabinet appears to have odd concerns for the health of Canadians. Apparently, we can eat all the tuna and turkey we want, but on October 16th, 1981, the Cabinet did not permit a foreigner to establish a business to own and operate weight loss centers. Although FERA is not concerned about the obesity of Canadians, they are concerned about our feet. On December 2nd, 1981, the Cabinet permitted a foreigner to establish a new business to import and distribute instruments and equipment for the non-surgical treatment and care of the feet. However, while Canadians will be able to carry on around their corpulent bodies on healthy feet, the Cabinet does not share the same concern for our hearing. In December of 1981, the Cabinet refused to permit a company to establish a business to import and sell custom-molded in-the-ear hearing aids. The Cabinet recognizes that Canadians need something to fight off the harshness of nature in the true north. On October 23rd, it gave permission to a foreign corporation to establish a business in Barrie to distribute lotions for the treatment of insect bites. But just in case the lotions do not work, the Cabinet has approved an application by a corporation to purchase a company which operates a funeral home in Orillia. The Cabinet is even concerned about what Canadians wear. Canadians may eat gourmet food, but they cannot wear foreign-produced furs. The Cabinet recently refused a foreigner the right to establish a business to operate a fur farm. But to satisfy that penchant for fancy clothing, the Cabinet allowed a foreign corporation to establish a business that specializes in made-to-measure undergarments for women. The Cabinet is even concerned about our spare time. On October 16th, it gave permission to a foreigner to import and sell pool tables. For those of us who do not enjoy billiards, the Cabinet ensured that we have other things to play with. On February 9th, 1980, the Cabinet allowed a company to establish a Canadian business to import and distribute yo-yos. Now, what emerges from all this is the Cabinet's picture of the typical Canadian and his wife. Fat, happy, non-smoking, deaf but dainty on their feet, and well protected against insects. A billiard-playing, beer-drinking husband and a wife with no mink, but with sexy underwear and a yo-yo. The paper which I have prepared deals with foreign investment review and Canadianization. A review of the developments since the enactment of the Act in 1974 indicates that there have been many developments which have had an impact on foreign investment review. We've had the principles of new business conduct. The government has passed the National Energy Program. All of these aspects are dealt with in Part 1 of the paper. The paper reviews briefly the chronology of events from 1960 to the Gray Report. The key sector approach to foreign investment ran from 1960 until 1974. These events and those which have taken place since 1974 are important. They will better equip practitioners to project where the government will take foreign investment review in the 1980s. Our clients may be interested in whether the legislation is constitutional. This issue is dealt with in Part 3 of the paper. For those of you unfamiliar with the regulatory framework of FIRA, Part 4 of the paper describes the scheme of the Act. Part 5 of the paper describes the review agency itself, and Part 6 describes the many considerations which a practitioner should consider when filing a notice. It is very practical. It deals with, is the filing of a notice required? What should counsel do before filing a notice? What does an applicant file? Where does an applicant file a notice? And how are joint ventures treated? The most important aspect of FIRA is the significant benefit concept and the crystallization of an applicant's plans into formal written undertakings. This is dealt with in Part 7. Our panel is going to review FIRA and the Canadianization issue. Part 10 of the paper deals with interventions. This topic, too, will be addressed by the FIRA panel. The courts have now had a limited opportunity to consider some FIRA cases, the Dow Jones case and the BC Forest Products case. These cases and the issues of FIRA and the law and extraterritoriality are dealt with in Parts 11 and 12 of the paper. The last two parts deal with turndowns and reapplications and FIRA in the 1980s. The Foreign Investment Review Act was enacted in 1973 and proclaimed in force in 2 stages. The takeover sections of the Act became law on April 9, 1974, and the second phase of the statute, the new business provisions, became law on October 15, 1975. As I mentioned, there have been many developments since the enactment of the Act with respect to restrictions and conditions imposed by Canadian governments on foreigners carrying on business in Canada. These are important for practitioners in dealing with review agency cases. Let me itemize them briefly. Firstly, the Minister has issued and published guidelines. The guidelines can be very useful in assisting practitioners in interpreting the legislation themselves. Secondly, the Foreign Investment Review regulations have been amended to improve and streamline the long form of notice required to be filed under the Act, and more importantly, to provide for a much abbreviated form of notice for small investment proposals. Thirdly, since the Act became law, Parliament and the legislatures of provinces have each enacted legislation to specifically deal with various industries. In at least one instance, a statute limiting foreigners is being deleted. In 1975, the Minister tabled the new principles of international business conduct. The principles were introduced and reflect broad government policy regarding the activities and responsibilities of foreign-controlled business enterprises in Canada. While the agency has not been specifically directed to consider the new principles in assessing significant benefit, counsel experienced in the review process have learned that the enumerated significant benefit criteria in the statute are interpreted having regard to the new principles. In 1980, the Prime Minister indicated that they would strengthen the Foreign Investment Review Act and expand the role of the agency by establishing a monitoring system to review periodically the activities of large foreign-owned firms, by publishing large takeover bids for foreigners, and by making financial assistance, likely through loan guarantees, available to Canadian-controlled firms in Canada who want to compete with foreign firms in the review process. The federal government has enunciated several policies which affect the involvement of foreigners in various sectors of Canadian business. For example, the Secretary of State in 1977 and again in 1979 confirmed the federal government's objective that a major segment of the publishing industry in Canada should be owned by Canadians. Apart from the energy sector, in no other industry have cabinet decisions in FIRA cases so clearly reflected the policy objective of the federal government. On October 28, 1980, the federal government introduced the National Energy Program. One of the objectives of that program was to increase substantially Canadian ownership of the petroleum sector. The National Energy Program documents as a clear objective of the policy of the Government of Canada towards greater Canadian ownership of the oil and gas industry. That program also makes reference to ownership trends in the non-petroleum energy sector, indicating the problem to be less severe in those areas. In the uranium industry, the government has indicated it will continue to insist on a Canadian ownership level of at least 67%. The government is also anxious to ensure that the coal industry does not become dominated by foreign-controlled firms. It has already indicated that any coal liquefaction plant will have to meet a Canadian ownership test. Lastly, amendments to the Canada Business Corporations Act have now been introduced to allow oil and gas companies to control their own Canadian ownership rate status, required to qualify for petroleum incentive payments under the National Energy Program. Similar amendments have been proposed for the Ontario Business Corporations Act. Now, the importance of these events from the standpoint of a practitioner is that government statutes, expressed statements by Crown ministers, and government policy must be taken into account in assessing the likelihood as to whether any new business proposal or takeover bid will be of significant benefit to Canada. Part 2 of the paper traces the historical development of efforts in Canada to regulate foreign investment. The overview will help to identify the political context and intellectual climate in which the legislation was passed, and will be useful in advising non-eligible persons who are developing investment plans for the 1980s. I mentioned that Part 3 of the paper deals with the constitutionality issue of FIRA. Although a more comprehensive treatment of this topic can be found elsewhere, I thought it useful to refer briefly to this issue in the event that a non-eligible person may wish to raise the issue. It can be argued that the Act is a constitutionally valid federal statute by virtue of 3 provisions of Section 91. There are also arguments to the contrary under Sections 92, under Section 92(13) of the BNA Act. I have concluded that the better view is that the regulatory scheme of the Act and the foreign investment regulations is inter vires the power of the federal Parliament based upon the peace order, good government power, and/or the Trade and Commerce Clause. The Act's application to transactions involving real property and the right to dispose of property should in most cases be regarded as necessarily incidental to the main purpose of the legislation. Part 4 of the paper reviews the application of the Act. As you know, the Act applies in 3 cases. It applies where a non-eligible person is proposing to acquire a Canadian business enterprise. All 3 concepts must exist. Secondly, it applies if a non-eligible person proposing to establish a new business in Canada for the first time. And lastly, it applies where a non-eligible person who is already here in Canada wishes to establish a business in an unrelated field. Again, Part 4 of the paper reviews in some detail the application of the Act. I don't intend to review it this afternoon. Part 5 of the paper deals with the agency itself. The agency is broken down into 3 branches: the Compliance Branch, the Assessment Bureau, and the Surveillance Branch. Again, the paper speaks to it, and I don't intend to cover it this afternoon. On a more practical aspect, Part 6 of the paper deals with the filing of a notice. The Act provides for a system of notification and review. A non-eligible person who proposes to acquire a company must establish that the new business will be of significant benefit to Canada. The filing of a notice is reviewed in the paper on a Socratic basis under the following headings. A, is the filing of a notice required? B, what should counsel do before filing a notice? C, what does an applicant file? D, when does an applicant file a notice? E, where is the notice filed? And finally, how are joint ventures treated? In determining whether a notice need be filed, counsel should consider the following factors. Firstly, you must consider whether the investment is specifically exempted by the Act. And I'm going to refer to the 3 or 4 exemptions that exist in the Act. Firstly, there is the small and the related business exemption. For acquisitions involving less than $250,000 in gross assets and revenues, and for acquisitions involving gross assets and gross revenues where they do not exceed $250,000 and $3 million respectively, and if the business is related, the Act does not apply. Secondly, there is a venture capital exemption in Section 33B3. Thirdly, there is a repatriation of control exemption in Section 33B4. That exemption applies where a non-eligible person acquires control of a Canadian business enterprise in circumstances where ownership will be ultimately repatriated to Canadians. Fourthly, there is an investment dealer exemption in Section 33B sub 2. Fifthly, Section 33E of the Act provides for an exemption in the case of amalgamations. Lastly, there is an exemption in Section 33D. That section would permit an upward, not a downward or lateral, transfer of shares, not assets, of corporations controlled within a corporate group to other members of the same group, although this may be an unintended exemption. Secondly, in filing a notice, we must consider whether the investment requires the filing of an application under the principal notice requirements. Suffice it to say there that you must be satisfied in the case of a new business application that in fact the applicant will indeed be establishing a new business under Section 3.4 of the Act. Nextly, you must consider whether the investment is exempted by the guidelines concerning corporate reorganizations. It may well be that the transfer of shares and/or assets involves a group of companies which are totally related. The reorganization guidelines provide that if the following three requirements are satisfied, the Act will not apply. Firstly, the person who acquires the shares or the property must be a corporation incorporated in Canada. Secondly, the person from whom the acquisition is made must be a corporation. And lastly, either one of the corporation owns all of the shares of the other corporation, or all of the shares of each of the corporations must be owned by the same corporation. The next question that I have raised is, what should council do before filing a notice? Assuming a decision is made that the investment requires the filing of a notice, in some cases it is prudent to make certain investigations before the application is completed and filed with the review agency. An applicant's pre-filing exploratory work may involve all or any one or more of the following items. Firstly, you should identify and understand the industry sector. Secondly, you must consider whether there exist any other legal restrictions or restraints in the industry. Thirdly, it is prudent to ascertain the government policy with respect to the industry sector. Fourthly, you may consider a meeting with the agency itself. If the proposed investment is a particularly sensitive one, it may be prudent to make arrangements for a confidential meeting with the Commissioner or Deputy Commissioner of the review agency. Representatives of the agency, after consultation with other government departments, may be in a position to advise council that it is unlikely the investment will be approved regardless of the commitments the non-eligible person is prepared to undertake. On the other hand, you may learn of the nature of the significant benefit commitments which the agency will be looking for so as to be in a better position to advise your client and to assess the likelihood of a successful application. Fifthly, you may consider meeting with other governmental agencies or departments. Now, what does an applicant file? The information which must be included in a notice is prescribed by the regulations. They provide for a short and long form of notice, depending upon the size of the investment. In takeover situations, a short form of notice is only available where the gross assets of the Canadian business, determined in accordance with the Act and the regulations, and the number of its employees, in each case at the end of its latest fiscal year, are less than $2 million and 100 persons respectively. Although the short form of notice is available to an applicant, you will want to consider whether to recommend that your client file the long form. It may, for example, be to your advantage if you have a difficult application, for example, one in a sensitive sector, or where you wish to submit relatively complete data and background in the form of commitments so as to ensure approval. The most important parts of the short form notice are sections 4.9, 5.5, and 5.6 for new businesses. While the agency may not require formal written undertakings with a short form notice, the plans for the target company or the new business should be prepared so as to include, in abbreviated form, the type and nature of the commitments normally given in connection with the filing of a long form of notice. Counsel should advise their client that the agency may, in any event, require the filing of formal undertakings. In some cases, if the industry sector is sensitive, it may be prudent to include in the notice more detailed particulars respecting employment, capital expenditures, and the like. This may have the effect of eliminating the need for the agency to require a long form of notice to be filed. The venture capital exemption requires the filing of information as well. The information is not substantially dissimilar to that required for a long form of notice. I have reviewed when the applicant must file a notice, where the notice must be filed, and lastly, the treatment of joint ventures. Part 7 of the paper deals with the topic of significant benefit and undertakings. Let me simply point out that in addition to the criteria in the Act, there are other considerations which applicants should take into account in trying to identify significant benefit. And they are as follows. Firstly, you should consider the principles included in the new Principles of International Business Conduct. Secondly, it will be important to identify the geographic location of the investment. Thirdly, the nature of the transaction. It is sometimes much easier to obtain FIRA approval in the case of indirect acquisitions as opposed to acquisitions where a foreign corporation will acquire a Canadian company and eliminate Canadian public ownership. Fourthly, you should consider the financial status of the Canadian business. Fifthly, and we will discuss in a moment, interventions. You should all be aware that in the review process, it is possible that third parties, unconnected with the investment, will intervene in the review process with a view to either competing for the takeover or simply wishing to have the application turned down. Sixthly, the elimination of Canadian ownership is a very important factor. 7, you should consider whether or not there is any existing underutilization of resources in Canada. 8thly, you should consider the past experience which the applicant has had in dealing with the agency. 9, you must consider the attitude of the government of the day towards foreign investment in any particular sector. 10th, unique technology, research and development. And lastly, you should review the industry sectors and industrial sector approach to significant benefit. Part 7 of the paper then reviews undertakings and the manner in which an applicant's plans should be crystallized into firm commitments. Jack, I think my time is running out. There are 7 more parts to the paper. I've just discussed them very briefly as to what they include. I think it would now be appropriate for us to commence our panel discussion.